Oh, tēnā koutou katoa, ngā mihi tuatahi, kia koutou ngā mema o te rōpū whakamana i te tiriti, kei te mihi, ngā maunga, ngā awa, tēnā koutou katoa. Ko horohoro te maunga, po kaitu te awa, ko Ngāti Kea, Ngāti Tuara, te hapu, ko te aroa te iwi, he uri o Ngāti Awa hoki ahau, tēnā rā koutou. Kia ora, everybody. Pleased to be here. And yes, I'm hoping the registrar will just click through my presentation as I'm speaking through my opening comments. Just sort of at will is fine. So, as we know, climate change is upon us. We've got increasing numbers of extreme weather events, Cyclone Gabriel, the Auckland floods, Dunedin floods, and now the dry areas of the country are at risk of fire, which show us the reality we're in. We're out of balance with papatūānuku and with each other. And the recent introduction of the principles of the Treaty Bill reminds us of the way that tino rangatiratanga and kāwanatanga are out of balance. The reaffirmations of tino rangatiratanga in te tiriti, and that those would be balanced with kāwanatanga show that they're out of balance. The reaffirmations in te tiriti that hapu tino rangatiratanga would be respected and that kāwanatanga would be fettered by that rangatiratanga has not been upheld. This imbalance with the environment and with each other is reflected in the way climate change policies and practices at the domestic and international level have been pursued by the Crown. We do need solutions to the climate crisis and the injustice crisis that exists in our governance arrangements. We cannot repeat previous mistakes in our transition. Otherwise, it'll entrench and deepen existing inequities amongst peoples and between us and the natural environment. Māori have solutions grounded in tikanga Māori and acknowledging te tiriti o Waitangi. We can see these solutions and examples all around the country, often where hapu and iwi have laboured to clear up their rivers, protect forests, whenua, wetlands or coastal areas. And oftentimes, as the tribunal noted in Ngā Mā Tāpono, Chapter 6, this labour has been against the Crown to stop the Crown's environmentally reckless, uncaring, extractivist approach. Māori aren't only ecological natives seeking to simply preserve and conserve the environment, however, but a Te Ao Māori relational worldview commonly situates extraction, use and development in that context of reciprocal relationships. And Hirini Moko Mead talks about the system of utu and the way that if something is taken, then something must be given back. And this framework places limits on the behaviours of tangata in relation to our whanaunga and whenua. I describe the transition we need from where we are now to a flourishing and abundant Aotearoa as the tika transition. Other scholars have described this as a just transition, but I think our unique context of Aotearoa needs to include tikanga Māori as a source of law and te tiriti. The UN Declaration on the Rights of Indigenous Peoples is also crucial in this framework as it provides those minimum standards that are expected at the international level and the expectation that state parties are taking steps towards actioning UNDRIP. In Canada at the federal level in 2021 and at the provincial level in British Columbia in 2019 has legislation which takes steps towards actioning those sorts of, realising those sorts of rights. This idea of a tika transition is threatened, however, by the repeating and replicating of the practices which have been significant contributors to climate change. The case I'm most familiar with, and which I believe illustrates this dynamic, relates to minerals in Aotearoa, in particular with regard to their desirability and use for green energy technologies. The governance and management of minerals comes under the Crown Minerals Act and does not respect tikanga Māori and a relational understanding of minerals or uphold te tiriti guarantees. The Crown assumes the sole right to manage minerals. Consultation processes for hapu and iwi do not allow for a substantive role in decision-making around permitting. At an international level, this power imbalance dynamic is reflected with the Crown unilaterally without Māori that is, negotiating and signing trade agreements impacting natural resources as though they have the exclusive ownership of those, including minerals. This is in breach of te tiriti and exceeds the authority of kāwanatanga, which should be fettered by rangatiratanga. In addition, international trade agreements encourage particular behaviours of extraction on significant large scales, which foreign investors or large companies are ideally suited for. So international trade and investment agreements normalise and lock in extractivist models and fail to substantively protect Indigenous rights. The investor-state dispute settlement provisions that Professor Kelsey has discussed in her evidence indicate that even if new agreements do not contain these provisions, the threat of disputes can have a chilling effect on domestic climate change policies. And given the very small steps we see from successive governments in actively upholding te tiriti guarantees, alongside regular breaches of te tiriti, any chilling of the status quo would be pretty dismal for Māori rights and interests. By pursuing options that Māori may not have been part of negotiating and may not agree to, these trade agreements in effect position Māori as in the way and Māori concerns as contrary to these agreements. International trade agreements exclude and marginalise hapu and iwi in the way they're conceptualised and the way that they're negotiated, and make it difficult for hapu and iwi to proceed with their own solutions for climate change. This includes when their rangatiratanga over minerals isn't recognised by the Crown, and neither is the right to free, prior informed consent. Trade agreements are conceptualised by starting from a specific worldview, a Western worldview where humans are centred and the needs of humans tend to be prioritised over the non-human world. There are assumptions about the way people behave, that people will be self-interested and self-maximising, and that there are natural rules which make a market function with supply and demand. These particular cultural ideas are generalised in trade agreements and assumed to apply everywhere to all peoples, but they don't. Indigenous peoples and Indigenous worldviews tend to prioritise relational connections rather than merely elevating humans. Individual property accumulation in some Indigenous cultures is frowned upon, and markets respond, we know, to things other than just supply and demand, money, for example. So trade agreements are negotiated by marginalising Indigenous voices or excluding them altogether in the context of a state-based world. And colonisation has meant that Indigenous peoples have been, to begin with, forcibly marginalised in that state-based world. But Indigenous peoples also have rights, even in the state-based system, and these aren't being upheld. UNDRIP has recognition of land, economic and governance rights, including the right of self-determination. So Indigenous peoples carry substantive rights in relation to international trade and investment agreements, and these need to be better recognised, including at a domestic level. Climate change is upon us and will require more challenging decisions globally and domestically. No knowledge system or worldview has all the answers alone. Indigenous knowledge systems and worldviews hold values and mechanisms, however, which support the careful consideration of the non-human world, promoting more respectful and reciprocal relationships amongst peoples and ways for rebalancing in the face of injustices. So the benefits of this approach of greater respect of Indigenous laws and worldviews is that a fairer, more just and environmentally sustainable world becomes more possible. Tēnā koutou.